Just before my learned friend jumps to his feet, we've been able in the short adjournment to provide the copy of the hard copy of the email correspondence and the case of Rianne.
That's very kind. Thank you very much. We have them on the bench. Yes. Yes, Mr. Turn.
Thank you, my lord. Can I be so bold as to pose a question at the outset, which in my submission is a question raised by these appealers? And the question is, what is a judgment? Is it an essay in which the judge is setting out why he or she thinks X as opposed to Y? Or is it a document in which a transparent reasoning process is before the reader and capable of evaluation and capable of checking? I suspect, of course, having put those two extremes, that the answer is possibly somewhat more nuanced. The answer might be, in many cases, more in the middle of those. But in my submission, this is a judgment that is an essay on what the judge thinks, not a transparent, reasoned document. And I say that with all respect to this experienced family court judge who has clearly worked extremely hard at this very lengthy document and in this very lengthy hearing, as the juniors behind and to my right have done also. And so the thrust of my submissions, perhaps with one exception, is about the structure of the judgment and whether it is good enough or not. I recognise, if I may, that at any first instance trial, including any potential rehearing, my client has a case to answer, and no part of my appeal or my submissions to this court is anything to the contrary of that. There are clearly worrying strands of evidence. But what I come back to and ask the court to come back to is, has the judge dealt with those strands sufficiently? And our answer with respect is no. And we start the embellishment of that slightly bold submission with, in the skeleton argument, with the noting of the quite cursory tour around the legal principles within the judgment, which, rather than just being a generalised complaint, has had a specific impact on the reasoning process in my respectful submission. Because it is just after that tour of the background and the legal submissions that the judge, in fact, announces her position. And that position is to agree with, believe, child 2, and I do hope I've got the numbering correct, child 2, and that becomes the cornerstone of everything. And one reading of the judgment, and it's obviously for this court to decide whether it's a fair submission and a fair reading that I'm urging upon the court, one reading of this judgment is that everything is made to fit. She liked child 2. Child 2 gave evidence with emphasis, with emotion, with affect. The demeanour was good. Everything about the judgment flows from that position. I'm not even saying that in this appeal that a family court judge hearing a child give evidence is not allowed to take on board demeanour. But what I am saying, and I do so respectfully to the judge below, is that when a core case, which shows the opposite to the demeanour, is put at some length by trial counsel, my junior, that core case has to be grappled with. And that has to be put into the balance alongside demeanour and judicial impression. And the core case, and the one specific example I'm going to go to, subject to being attempting to assist this court further in any inquiries, is the role of the maternal grandmother. Because at the core of the father's questioning, my junior, Mr. Laing Brown, questioned, he tells me, the maternal grandmother for approximately 2 hours about her role. At the core of that questioning and at the core of his submissions, it can only have been obvious to the learned judge that we were suggesting influence that was other than benign on child 2 and the others. The maternal grandmother influenced and caused some of the allegations and the emotional landscape in which the allegations came about. So
those were the possibilities the judge had to consider. That the allegations were true or that they were false because the grandmother had put the child up to it.
Yes, and that was at the core of our case, whilst always recognising, my Lord will forgive me, I know, this court does not need reminding of the fact that because we put forward a case, the burden does not shift.
No.
I know that my Lord has that well in mind, but yes is the short answer. And so, when we go past the treatment of demeanour to the judicial assessment of the maternal grandmother, which
we
was
pause on demeanour before you come to it.
Of course.
Your submissions seem to suggest that the judge decided this case on the basis, as it were, of demeanour alone. I mean, one can imagine a completely different set of circumstances in which an allegation appeared to be extraordinary, unsupported by any other material, highly improbable, but somebody goes into the witness box and the judge is so impressed by their manner of giving evidence that the judge makes a finding in accordance with the evidence. Now, I mean, that would be a case in which the case had been decided effectively on the basis of the demeanour of the witness. But before you move on to develop your submissions, this is not such a case. There was, with respect to Mr. Toomey, who has pointed out the limits of this, a considerable amount of other evidence that confronted the mother and your client. A very considerable amount of other evidence coming not only previously from this child, but from other children, and from the general overall circumstances of the case. And so I don't want to, as it were, allow you to feel that the submission that this case was decided on the basis of child 2's demeanour resounds, at least with me.
I'm grateful. My Lord is right. There is a great deal of evidence, and there's a very steep incline to the slope that my client faces at any first instance tribunal, including before Judge Sapnara. I have no difficulty with that and respectfully agree. The issue is, has the judge dealt with the evidence fairly and transparently so we can see the reasoning process? And in my respectful submission, she has gone, if not wholly to, when I say demeanour, I should say, my Lord, I mean believability of child 2. So not quite as limited as demeanour. She's believed child 2 partly because of demeanour in the witness box, and expounds at some length about why that is. And the structure of the judgment means that because that comes first, and again I don't want to take an unfair point or a silly point just because of the positioning in the judgment, but because that comes first, it is easy to see it as the cornerstone and the start of the flow of everything else that follows, because it couples with.
Would it have made any difference if the judge had done as many judges will do, say, well, I'm not going to spare you, the parents, the misery of listening to me give a long judgment, and I'm going to tell you now what my conclusion is, and it's this. I will now give you the opportunity to leave court if you don't want to stay, but if you want to stay, I'll now give my full judgment. I mean, how does what happened here differ from that?
Well, it differs markedly with respect, my Lord. That humane and commonplace approach to the humans in the court and their feelings in the court and announcing a decision is not part of the reasoning. Is to say, I'm going to find these allegations proved, now here's why. And when the judge goes to the here's why, the substantial body of the judgment, what we look for in my respectful submission is the transparent reasoning process. What is different to here is that we've gone from, we go very quickly to why I believe.
But so it's not where it appears in the judgment. It's just that you say that that's a sign of the process that was being undertaken.
Absolutely. All right, absolutely. Thank you, my lord. I'm grateful.
Well, forgive me, why do you say she went very quickly to that?
Because it comes at quickly is perhaps a relative term with the size of this judgment. But when we get to A102, for example, up to A102, which is electronic 109, we've got the 65 paragraphs before the section on the law are background. We then have the law. So sorry. We then have the law, and then we have an announcement at A102. I'm so sorry, I think my page of references are out, forgive me. It's at paragraph 125, A112, forgive me, my lord. Prior to paragraph 125, in my respectful submission, it's preamble and background and law, and the law is short. Now, the judge does refer, as many judges do, I accept, to agreed legal notes that have been put in by counsel. But it is incumbent on a judge that is going to go on and take, for example, judicial notice of things. It's what the learned judge purports to do. It's incumbent on the judge to set out the law and the case against in order to deal with it transparently and fairly. But we leap to, instead of any of that, we leap to, I'm going to start at 125, I'm going to start with my summary of the oral evidence of NEMA. And it's not a summary of the oral, forgive me, child 2. I'm going to start with my summary of the oral evidence of child 2. And it isn't a summary, it's decisions about child 2, without setting out a history of potential inconsistencies. If the judge had wanted to dismiss all of the inconsistencies and all of the history, it could have been done, but it wasn't. It reads as though we've leapt to, I believed her, and therefore, before we go into the body of the judgment. So I hope that answers my Lord's questions. Paragraph 125, paragraph 126, in my judgment of all the witnesses, she was the most reliable. Her oral evidence was powerful and compelling, delivered calmly and quietly.
But this is a pretty commonplace tool that judges use when they are looking at the witnesses. They do give a pen picture of how they presented. It doesn't necessarily mean that they're reaching a conclusion. And indeed, we see later from 351, the judge then sets out her reasons for accepting the second and third child's evidence. So I don't read this as saying that she's accepting everything that she said, or even she's talking about the impression she gave as a witness, isn't she?
My Lord, my respectful submission, it goes further than just an impression or a summary. It goes to the judge's judgment of the witness. It's a jump to the judgment of what I've made of her as a witness. And again, because it's not. I'm grateful to my Lord and Lord Justice Peter Jackson. It's not necessarily the positioning of it. It's that underlies everything else, and that everything else in the structure of this judgment is made fit. And I'm going to come to, at some point, how that tallies with my one example of the treatment of the maternal grandmother and her evidence and her. When we look at paragraph 126, the oral evidence was powerful and compelling, delivered calm. She gave evidence after the other two young people. She'd given a statement to the police previously, underscored by the fact that another young person did not want to be even seen during my pre-hearing video with her. And she goes on about the impression at the start of the evidence, subject to the preamble and the law, of child 2, which then, in my respectful submission, sets the yardstick and sets the cornerstone for the rest of it.
Could you give us, after consulting, just a rough account of the progress of the trial? That there was, were there 17 days of evidence, or was it 17 days
I'm hearing 1 day of housekeeping, 16 days of evidence.
16 days of evidence. And
And then written submissions only, not oral submissions.
so that's helpful. So we have 16 days of evidence, and approximately on what day did child 2 give evidence, or what days?
Judge does list the witnesses, but I don't know if it's in
Well,
order.
we can come back to that. And maybe we could just interject before it gets forgotten when somebody's worked out
Yes, thank you.
at what stage. Because the point that I'm making, as will be obvious to you, is that before child 2 gave evidence, the judge cannot be considered to have made up her mind about it, because it's not like one of those cases where the judge will view, maybe repeatedly, and what used to be AVE interview before the trial, so that the judge has foreknowledge of the manner in which a young person will give evidence, because there was no AV interview of this young person.
And the allegations were made for the first time, the very serious end of the allegations were made for the first time in the witness box. So indeed that day 7 was child 2.
Thank you. And her evidence lasted for...
Over a day.
My Lord, I can help. She started on day 7, and it was a Friday, and it went over a weekend, and she continued, I recall, on the Monday.
And her evidence as a whole was about a day.
Day and a half.
Day and a half.
2 days altogether.
2 days.
Because I know, my Lord, even though I wasn't there, that because of the fresh allegations, there was a request and an agreement that there would be more questions posed overnight, and the questions were all put through the Guardian's advocate. So written questions were prepared overnight on the new evidence.
Right, so we start with what was expected. Friday then turns into something rather unexpected. Everybody takes stock and regathers on the Monday in order to deal with it as
Carry
best.
on. Yes.
I understand.
Yes. So, my Lord, to answer my Lord's point, I respectfully take the point. I'm not saying that this is a predetermination before the evidence started. I'm saying this is a judgment that does not come up to the sufficient level of transparent reasoning, is what I'm saying. Can I just deal with judicial notice and the way the judge dealt with the law? Because drawn to the judge's attention was the decision, we have it at the authorities bundle, electronic page 3, which I think, I'm afraid to say, is the entire judgment on one page with a scroll, but it's Mr. Justice MacDonald in P, the judicial notice in child sex abuse cases, paragraph 577. So electronic authorities 3, para 577, in which that learned judge sets out how he is satisfied that this court, bearing in mind a great deal of information and past experience, including the Cleveland report and others, I'm satisfied this court can take judicial notice of the following matters. And he sets out the 12 paragraphs there, starting with children are suggestible, memory is prone to error.
Sorry, I'm just catching up.
I'm so sorry.
577 of this judgment.
577. Electronic page 3, but it's the scroll page, I'm afraid.
So this is after, this is in the course of considering good practice with respect to handling allegations. Right, so he says that there are 12 things one can take judicial notice of.
Yes.
They're not the only 12 things.
No, indeed. No. I completely accept it. My point, my small point, is that this was drawn to Judge Sapnara's attention. It doesn't feature in her analysis of the law. It's core to the case, and in a judgment in which she is purporting to take judicial notice of various other things, one might have expected that in particular paragraph 7 of Mr. Justice MacDonald, the influence, accounts given by children are susceptible to influence. This will lead into the maternal grandmother point and whether that was properly or fairly dealt with by the court below. Not mentioned. So moving from judicial notice and dealing with the law, I do suggest that and recognise that it's not the first time that a court is left with a witness that is believable in the witness box, but with contradictory counter information away from the witness box. It is, in my respectful submission, I suggest I don't need authority for this, but in my respectful submission, it's incumbent on a judge to deal with that juxtaposition of a believable witness with, including but not limited to demeanour, with the contraindications from the papers. And in my respectful submission, that hasn't been done. I'm not going to attempt to repeat or embellish the submissions made by my learned friend this morning. On many of them, we pray them in aid. The contradictions, the corroboration. I don't say prior complaint, if I may. I hope my Lord doesn't think I'm just jumping on a bandwagon, but I don't say prior complaint. I do say that this is different to prior complaint because there's prior contradiction that we'll come on to. And an example of that would be the physical abuse allegations, the being beaten with sticks and heavy tools so that they hurt and caused injuries, but nothing was seen by anyone. Again, my Lord might make the point, and I would struggle to disagree with it, that such evidence is commonplace in the family court. And again, my point in answer is that the issue here is whether this judge has dealt with it properly or not, dealt with these points that are being put to her in some detail in submissions and in evidence. So can I come to the example that illustrates what it is, I hope illustrates what it is we're attempting to submit, and that is the judicial assessment of the maternal grandmother. It isn't, on my reading and my learned junior's understanding, it's not terribly controversial in this case that the maternal grandmother did not like my client. Neither is it controversial that the very serious injuries, allegations, came about whilst child 2 was in the care of the maternal grandmother. The judge deals with the maternal grandmother by concluding that she's an unreliable witness and historian. That's paragraph 319.
Can we just, I just want to take this slowly.
Certainly not.
She doesn't like your client. You were talking about the allegations, the very serious allegations.
Yes, the new
being made
serious.
While the child was with the maternal grandmother. The sequence of events, as I recall it, is that on the 10th of February, child 3 made her allegations. On the same, at the same point, all 5 children, except for the eldest, left the home. No, I'm being told I was wrong about that. So can we clarify exactly who went from the home when?
Yes. Yes. Until the 17th. Yes. Yes, I know. Yes, thank you. I'm grateful. The child I'm talking about, my Lord, child 2, stayed at the home with the parents, the stepfather and
No. I think if we take them one by one, we can leave child 1 alone because effectively she stayed. But child 2 went to a friend for a couple of days and then to the grandmother.
My Lord.
Yes, Miss Edward.
I think it's perhaps easier. On the 10th of February, Mr. Stewart's client was arrested.
Yes.
And so he left from that day and has not returned. The child 3 was removed immediately. quickly and did not return. The 3 youngest children were removed about 2 days later after a contested hearing.
Yes.
And child 2 left of her own volition on April the 17th, stayed with a friend for 2 days,
Right.
arriving at maternal grandmother's on the 19th of April.
Thank you. I had missed that. So she stayed along with child 1.
My lord, yes.
Right. For some weeks, a couple of months. And then went to the grandmother's, where she has remained.
Yes.
Now, we've been taken by Mr. Toomey, for example, to a time when child 2 was gave a police statement in mid-May or sometime around then, in which she made some serious allegations, not as serious as subsequently, but serious allegations. We've been taken to a time which I imagine is after October, when she was interviewed by the independent social worker. Just going from how old I was told she was
Yes.
at that stage. She made various statements which included allegations that were not always consistent, but despite having been for many months with her grandmother, she didn't unleash the account that she gave in the witness box.
Yes.
Right.
Until the witness box.
It's in that context that you're making your submission about the influence of the maternal grandmother being the source of the allegations.
Yes,
And in your case, your appeal relates to every allegation.
it does.
So you don't differentiate between the allegations that were made on in May, or those that were made to the independent social worker, or those that were made from the witness box. The judge was, you say, obliged to explain why she accepted those matters and that she failed to discharge that in relation to every single finding that she made.
Yes. And as an example of the judicial reasoning, and we say deficit in the written judgment, I'm alighting on the treatment of the maternal grandmother as an example. And so it may be the starting point. The judge finds the maternal grandmother to be an unreliable witness and historian. That's paragraph 319 and 322. I have that at electronic 148. She described her as a contradictory, confused and confusing witness. The clear dislike by the maternal grandmother of my client goes back years. We have evidence of it in 2013 at C986, which is electronic 1205. We have the safeguarding checks by Kafkas in those proceedings, in which there is evidence of the disapproval of my client by the maternal grandmother. It may be that that disapproval is as a result of the unmarried status of her daughter with my client. The judge certainly thought so, and the judge was concerned about. The judge concluded that the maternal grandmother was concerned that she was shamed that the mother was still married to the other father. That's at paragraph 330. At 419 and at 417, the judge deals with her conclusions, with the conclusions in relation to the grandmother. And at 417, and I ask the court to have a look at 417, which is electronic 163. The judge says, I accept the evidence of the girls that they were not coached or influenced by anyone else. Pausing there to take a point which I hope just isn't a minor trial point. If you are influenced or coached and don't know it, that's what your evidence might be. but that's a small pause in the scheme of things.
I'm sorry, I'm just trying to pick up what you've just been reading. You said 419?
417.
417, thank you.
Accept the evidence of the girls that they were not coached or influenced by anyone else, including their grandmother and their father, into making these allegations. And then at 419, again back to child two's real distress from the witness box, as described earlier in the judgment, and what the judge considers to be the grandmother's genuine distress at the nature of the allegations when she cried and exclaimed. Her evidence was spontaneous and passionate on this point, and the judge says this: I have no doubt from the evidence that I've heard and read that if these allegations were known in the wider community, it would bring shame on the family, and in fact would likely have made marriage arrangements more difficult to secure and potentially reduce the size of any dowry. I refer again to child two's assertion that no one would want anything to do with her if they knew. That is the explanation that the learned judge gives for rejecting the case put forward, the core of the father's case put forward about the influence that the maternal grandmother has had.
So apart from the fact that she doesn't like him, what was the father's evidence in support of the allegation that the maternal grandmother had caused a 16-year-old and a 17-year-old to make these allegations? Well,
in 2012, my lord, and the reference for this is the local authority chronology entry, which we have at C097 electronic 316 for the 1st of June of 2012. There's the recording that, as I understand it, was not controversial at the hearing, that the maternal grandmother told one of the children to lie about the father. The recording refers to a second interview of that child.
Where's the reference to that?
So that's the local authority chronology entry. Is my lord asking for the page?
Yes.
Yes. Electronic 316.
So A295, or C97 rather, in our bundle.
C97, A295, electronic 316.
So what are we reading here?
This is the
date of
1st of June. Agreed. The black writing is the original chronology. The red writing is that right? If I'm wrong, I'll correct myself. Sorry, my lord, for the conversation at the bar. My understanding is that the black writing at C97 is the chronology, and the red writing is my learned junior's submissions that followed.
Yes.
So that's the reference to that. We also have the assessment with me at C373 by the independent social worker, paragraph 1219. The possibility that the grandmother and father are coaching child 2 should not be disregarded. C373.
That's mentioned in the judgment, isn't it?
Yes, it is. Mentioned, but my respectful submission not dealt with. As this whole issue hasn't been dealt with properly, in the sense that we get to paragraphs 417 and 419 of the judgment, and it comes down to shame. Rather than a forensic analysis of the history of dislike, the history of shame going the other way, and the history of allegedly telling a child to lie, in the context of the judge deciding that the maternal grandmother was an unreliable witness.
Well, she decided that the maternal grandmother was a pretty hopeless witness of fact, but she did not find her to be malign. She found her to be very committed to these girls.
She did, and that is what I complain of. The way that the judge found that, because in my the submission ultimately boils down to my expectation on behalf of my client that in order to dismiss the core case, his core case, the judge would have set it out, would have set out the law, including Mr. Justice MacDonald, as was put to the judge, and explained in a way that is transparent and one can see the reasoning process.
Well, take Mr. Justice MacDonald. Why should a judge have to set all that out in relation to a case where she has to decide whether one person is telling her the truth or another? She's made clear and directed her attention to the issue of coaching, which was your proffered explanation. You didn't have to provide an explanation, but that's what you proffered.
Yes.
Why should a judge in the working court have to go through a list of 12 issues, most of which are entirely irrelevant to this, when actually what you're relying upon is the possibility of a child being put up to make false allegations, which anybody who's practiced in this area knows is not a particularly common, but an ever-present possibility.
Because, my lord, simply, it is a trial judge's duty in putting together a judgment and explaining the decision to engage with the closing submissions on behalf of the litigant. And this was Mr. Laing Brown's core closing submission. And that's why I've alighted upon it, because there were, I suspect, my lord might be able to count 20 submissions that we might say Mr. Laing Brown made, but I accept that there has to be a practical limit on what a judge is to do. But when the core case is put in the way it was to Judge Sapnara, this, in my respectful submission, is not enough of a transparent explanation to deal with that core case, which is founded in some evidential history. And so my...
Take 389 in the judgment, page A151, electronic 158. There are 4 or 5 references to coaching in this judgment. Some of them relate to the allegation that the mother was coaching the children not to speak. And some of them, including this one, relate to the possibility that the grandmother is coaching. But I mean, here in a paragraph, one has the judge directing her mind to the issue of proactive coaching and whether the mother really believes that is happening or not. So that she finds it very hard to understand why she goes on visiting the grandmother if she really thinks that the grandmother is the origin of all her troubles.
Well, I respectfully agree, and I recognise respectfully my lord's point. None of that at 389 deals with our history founded in the evidence of dislike and shame, as the judge finds, about the mother's relationship with my client and therefore the dislike of my client. And that grounding of this as something more than fanciful. This isn't, in my respectful submission, a fanciful proposition being put forward by the father. He has some evidential basis for it, and the judge should have dealt with it. And at 389, she isn't. The learned judge didn't deal with it. There was a different aspect to the coaching side of it, but not the core father's case. And I'm not, forgive me, submission's never improved by repetition, but I'm not contending for a piece by piece going through of every submission made, but I am contending for a duty on a court to engage with the central submission. And although coaching is mentioned, it's not dealt with as the central submission that it was. And so that takes me, I think, my lord, if I may, to A149, 2 pages before the page just looked at, so electronic 156, in which at paragraph 372, I reject the suggestion that child 2 was influenced by the grandmother and her own father because she was living with her grandmother and seeing her father at the time she gave her police statement or evidence to the court. I accept what child 2 said about this. In my judgment, it is likely that she was finally in a place of safety and in common with very many victims of abuse, she had the time and space to realise and then become comfortable enough to articulate what had been done to her. Which is, in my respectful submission, unimpeachable if the judge has gone through the process of dealing with that historical evidence, of the problems, of messages from the grandmother to the children, and her dislike of my client. On that point, my lord, I think that concludes my submissions, and I'll move on briefly. I said 40 minutes. I suspect I'm coming to the end before I open myself up to any more questions, to the question of physical abuse, and that is the judge's treatment of this issue at paragraphs 158 to 161, electronic 124. In which the judge is setting out there at paragraphs 158 onwards. 158, my client hitting child 2 with a stick when they lived in the house. Paragraph 160, hitting lots of different sticks. Paragraph 161, asked why she had not told the police about being hit by my client with his work tools. I just didn't want to. She said he used lots of different tools, did not really know the names of them, but they included a hammer. Usually hit her on the hand or her leg, hit her really hard and it was painful. She used to have injuries. Didn't report the abuse. The absence of evidence is always a difficult trial and perhaps even more difficult appeal point. But my lord, the judge should have dealt with, given that potentially exaggerated account of being hit really hard and injuries being caused, should have dealt with the absence of any notification from school or from anyone as to a series of injuries that corroborate. So it's an absence of corroboration, but it's also the fact that no one has seen such injuries is also a point against the veracity of that account. And that all, in my respectful submission, should have gone into the mix in a way that it did not at all in the judgment, and certainly did not transparently go into the judge, transparently dealt with by the judge. And so, to sum up, my lord, we say that the judge was far too influenced by the presentation of child 2 in the witness box. We say that the judgment is deficient in dealing with the contrary evidence, and the judge is using terms such as judicial notice, is using her own personal knowledge in a way to explain away the contradictions to tally with her assessment of the witness, which was so influential to her. It might be permissible, in fact, in my respectful submission, is permissible, if explained properly, for a judge to say, I believe a witness. Of course it is. It's part of the, maybe part of the judicial function. But the contraindications to what that beliefs, prima facie believable witness is saying need to be dealt with properly. On the issue of the global nature of our appeal as opposed to that of the mother, I simply say what is said in the skeleton argument, that to unpick the assessments that are necessary in this case and to decide, for this court to decide what is or is not necessary, is, in my respectful submission, a difficult process.
You're with Ms. Brannigan's submission that really it's intertwined.
Absolutely intertwined. It couldn't possibly safely, in my respectful submission, be unpicked.
So, I mean, the consequence for your account account of the matter is really that it's all or nothing.
Indeed so. Indeed so. Can I just turn my back and check? Thank you, my lord. Can I assist further in any way?
Just in relation to the your client's case about the grandmother's role,
Yes.
I mean, it's fair to say, isn't it, that at 460 to 465, the judge does consider it and its development and pretty comprehensively dismisses it.
So sorry, my lord, I'm struggling for the page.
460 is at A162.
Thank you. Very grateful.
This is through the lens of the stepfather's evidence
Yes.
itself.
So, my lord, I'm so sorry. I was so busy looking for the page, I've now missed or mislaid my lord's point.
Well, all I was suggesting to you is that in those paragraphs, 460 to 465, the judge does consider and very robustly dismiss the what she refers to as the conspiracy allegation, which developed during the course of the proceedings to involve not only the grandmother but also the mother.
My lord, that is another example, in my respectful submission, of the nature of this judgment, which is to robustly do one or the other. She robustly accepts child 2. She robustly dismisses here. But has the learned judge dealt with the historical points and the grounding and evidence here? My respectful submission, the learned judge has not. It's impression, and it's robust, and it's based on the oral evidence. But there isn't an acceptance of the history of dislike, the worries about shame, although shame is mentioned by the judge, bringing it forward so the judge can then do an assessment and then robustly dismiss the father's case if that's what the conclusion was. So the complaint is only the absence of the transparent, full reasoning. And I respectfully suggest that isn't enough at paragraph 460 on to get the learned judge to the dismissal of the case. Excuse me. Yes. It's just been pointed out to me, and I'm grateful, that 460 onwards is actually it's Mr. Diamond in evidence. My client in evidence.
Yes.
Give me, that's the second time. Give me. I'm grateful.
Yes. And he gave evidence for no doubt not less than a day.
Yeah. He was overnight, wasn't he?
Yeah.
As well?
At least 2 days, certainly overnight. Yes. Can I attempt to assist further, my lord?
No, thank you very much.
Thank you.
Thank you, Mr. Toome. Yes, Mr. Poole.
Well, my lord, my lady, on behalf of the local authority, as the court knows, the local authority opposes this appeal, and the court has got an argument at a 187, and I don't intend at all to repeat what is set out there. My lords, my lady, the fundamental position of the local authority is that before this court, and what we are looking at as the heart of this appeal, we're considering this judgment of the lower court, and this is, in my respectful submission, a detailed and extensive analysis of the evidence that was before that court under difficult circumstances, but the evidence and what we read in great detail is the learned judge's evaluation and assessment giving rise to the findings that she made. Based on that analysis, in my respectful submission, the court was perfectly entitled to make the findings that were made, and that neither appellant comes anywhere near crossing the high standard, the high hurdle that's required to overturn that fact-finding judgment on appeal. I say from the outset, and as I say in the skeleton argument, this is a very detailed judgment. There's no dispute about that. As this court knows, It was delivered over approximately 7 hours and runs to 82 pages and 532 paragraphs. Within that detail and lengthy judgment, there are still places, and the court will have noted, where the learned judge says, for the brevity of this judgment, I won't go into every particular detail. I'm thinking about the legal principles. One point that's made in challenge is that the learned judge didn't address all the legal principles. My lords, my lady, at paragraph 66 of the judgment, which is A102, you will have read exactly why. Despite the length that we were to go on to understand of this judgment, the learned judge is saying there, I do not intend to set out that detailed law in my judgment, as that would serve only to make the judgment even longer than it is. And that position was predicated on what was in essence an agreed legal framework, and you've seen that in the written submissions that were put before the court. If I may, I'd seek to address 6 points that have been raised particularly today, and I'll take the points as briefly as I can assist the court. Firstly, I would propose, my lords and lady, to look at the basis of the mother's appeal, and this is the difference between the appeal that's brought by the first appellant and the second appellant. The fact that the mother, the first appellant, only seeks to challenge certain findings, whereas the second appellant, as we know, seeks to challenge all findings. I'd seek to then go on to the question of credibility and the submission, and inviting this court to reject the submission that the analysis in the learned judge's judgment of credibility is limited to demeanour only. I'd respectfully say it's much, much more than that. I go on to talk briefly about the issue of judicial notice, res judicata, influence of the maternal grandmother being the focus of the second appellant's case, and also the point that has been made that certain submissions were not addressed in the judgment. If I may then just, considering the basis of the mother's appeal, the basis that she appeals only certain findings, I'd invite the court to consider this in the light of the mother's evidence as it transpired through that hearing. We heard evidence from the mother over a number of hours, spread over a number of days, and her position is set out as it ended up, is set out in the judgment, and I'm referring particularly to page A137, paragraph 292. What is clear in my submission, the mother's evidence shifted quite an amount as she gave her evidence. She was challenged on what she'd said to various people before, and we read about that in the paragraphs that run from 296 particularly onwards. But where her evidence settled, 299. In relation to the massaging allegations, the mother's case not seen the children ever massage the second appellant, denied massaging herself. Paragraph 300, in her oral evidence, the mother said the second child was making up these allegations. So at the heart, and it goes on, paragraph 301, the mother's case is that the second appellant had many opportunities over the years to make the allegations, and she chose not to, and that the allegations are not reliable or truthful. So, my lords, my lady, the basis of the mother's case, as we heard it, was that all the allegations that were being made by the second child, specific allegations that she was making, were untruthful, and that the mother was to be believed over the evidence that the court had heard, and indeed the evidence that the court had, prior to the second child giving so much more evidence from the witness box, but the evidence that that child had given in written form. and that included the earlier allegations that she'd made. And what we're left with when it comes to the appeal is the mother saying that she challenges only the matters that came out in oral evidence. And so that leaves on the mother's appeal finding number 4, for instance, 4A, and that is that the second appellant encouraged the second child to massage his body and feet. My mother's case was that that didn't happen. And 5, and my lord's already had the exchange with my learned friend for the first appellant, the difference between mother accepting 5 and rejecting 6. But the overall point I make, my lords, my lady, is that it may seem something of a curious inconsistency that the mother on the one hand is saying, this child of mine, second child, has lied about all these things, and yet she appeals only the matters that come to light in the fresh oral evidence. The point being, of course, that that leaves on the mother's case perfectly sound findings that the lower court made based on evidence that the mother fully contested and evidence that she sought to persuade that court was untruthful.
But you may often take the view or be advised that, that certain things they don't accept are still not properly challengeable.
My lord, I accept that point, but it goes, in my submission, this goes to the heart of what the mother is saying about this appeal, that this young person could not be believed. And that her case was, where it comes to a dispute, and I've taken you to the part of the judgment, where it comes to a dispute between my daughter and me, I invite the court to accept my evidence across the board. And of course, we know the court didn't.
But my understanding is that the challenge is to primarily to that part of the evidence which came for the first time during the course of the oral evidence at the trial. And there is a logical basis upon which one could say, well, I can't challenge the factual findings on the other matter, but I can challenge these factual findings. I don't see any real difficulty in that approach. I don't see it's in some way inconsistent or undermining itself.
My lord, my submission is that what it leaves on the basis of the first appellant's position is it leaves findings that are not challenged, that are based on evidence, where she said very clearly that that's not true.
Well, I'd say it's a slightly higher hurdle.
Yes, yes.
Does it go any further than that?
If I may then move on to the point of the credibility limited to demeanour, I'd respectfully invite this court to reject that. At the heart of this detailed and lengthy judgment, in my submission, we really get to the discussion the learned judge comes to of the evidence that she has summarised and heard, and it starts perhaps A144, paragraph 343, where she introduces what will become the section that deals with a number of the conclusions that she comes to, comparing one child's evidence to another, and indeed comparing the evidence of the adults to that of the children. So 343, having regard to the totality of the evidence, I'm entitled to reach a common sense conclusion on the balance of probabilities, and I do so on matters which I consider to be relevant. That's by way of a perhaps a pithy introduction to what then comes. And what comes from, in my submission, 3, 4, 5 onwards, is a clear analysis of evidence, not limited in any stretch of the imagination to demeanour only. A clear running through of areas of the oral evidence that the court's heard, the written evidence that's been before the court, the submissions in due course are dealt with, and how the judge has come to her conclusions. So we read, for instance, where she's talking about embedded detail in 346. we read in 349, surrounding circumstances, each, she says in the very final sentence of that page, each had the number of opportunities to embellish their evidence, but they chose not to. It goes on to talk about the impact at 350. The clear, in my submission, the clear conclusion that this court can reach is that there is far more that gave rise to the findings that the learned judge made, far more than simply saying, I'm looking at the demeanour of witnesses, and I'm deciding how I'm going to approach this complicated case on that basis. And certainly more than the submission that's made based on the structure of the judgment, that the learned judge gives the child two's, the evaluation of child two's evidence first, because this is the beginning of a linear approach that that court had to how she is going to deal with the conclusions that she comes to. So what one reads from those paragraphs onwards in my submission is clearly an analysis of where there's exaggeration, and I think my learned friend Mr. Toomey referred the court to paragraphs 368 and 369, areas where the evidence of two of the young people did not fully tally, but the views that the learned judge expressed on that. It's clear in my submission that what we are dealing with when it's being suggested inconsistencies, perhaps my Lord's word, that differences is more really what the court is analysing. And 391 at A152 explains the judge's thinking on that. Paragraph 390 of the judgment has been brought to the court's attention as an example of a clearly illogical, certainly a part of the judgment that is criticised. In my respectful submission, when one reads 390 alongside 345, the logical conclusion is that the judge is talking in 345 and 390 about the same two young people. And that what we have in 390 appears to be a typing error. And that is a matter, if it's taken up with the energy it's been taken up today, it should have been dealt with by clarification. It's abundantly clear in my submission that they're the same two young people. The description of their evidence, the description of comparing the two. That would give, in my submission, clear context to what flows. 391, 392, clear understanding of how the judge is then approaching those two young people, and it does, in my submission, follow that what we then have between those two young people, so 2 and 3 rather than 2 and 1, what we have between those two young people are perhaps differences, not inconsistencies. I've drawn the court's attention to that part of the judgment that I respectfully suggest goes to the heart of matters, and it is, when one reads through that, there's clear examples also of the judge alerting herself or being aware of, as well as embedded detail at 346. She touches on the issue at 347 and indeed 353 and dismisses any suggestion of story creep. All principles well known to this court, all aspects that one would expect a judge to deploy, or considerations that one would expect a court to go through in considering such a complicated and detailed judgment. So my Lord, my Lady, I would respectfully say that there is nothing to really pin on this judgment, or there is no basis to suggest that this judgment is undervalued to such an extent that it is simply an assessment of demeanour that then leads to the rest of the evidence being fitted around that, and indeed the conclusions that are suggested to have followed from that. On the question of judicial notice, I would respectfully invite this court to consider what the learned judge says. I come back to the point that my lord made earlier today, that judicial notice is mentioned on a number of occasions, and there's two particular aspects that are brought to this court's attention. Is it judicial notice, or is it the experience of a judge dealing with these kind of cases, an experienced family judge putting into the context of this court her experiences and her considerable knowledge of these matters? What it isn't, in my submission, is in any way an attempt by the learned judge to substitute her own background, alluded to in one of the skeleton arguments. That's clearly made clear from the outset of the judgment that the learned judge, while she shares the background with this family, that is no substitute, that is no basis upon which she's made a decision. That's paragraphs 30 and 31 as A97. And what she is doing is simply putting the context in which she is there, but she's certainly making a decision based on the evidence. The judicial notice points don't, in my submission, go to the heart of the decision that the court was making, and certainly don't render these findings unsafe. On the res judicata point, if I can help the court briefly on that, I come to the point that my lord made, that findings had been made by the lower court, by the district judge, and of course we know from Re B, Re ZZ, that there are procedures that need to be gone through to set aside the findings. My lord's words were that there is a process that has to be followed. No party in the lower court was inviting the court to set aside the findings. It said that the judge should have done it of her own volition, but no party, it was the case of none of the parties that it was that what this judge was being invited to do was to go behind those findings, having considered or herself having indicated that she was going to rehear those matters. And it is clear when one looks at the closing submissions of the mother that position was indeed her position. I'm reading from C150, paragraph 21. It is accepted that it is not possible to go behind the judgment made by the London District Judge in the private law proceedings.
Well, the whole thing was really a bit unusual in that if anybody was asking for the findings or the conclusions reached by the district judge to be disturbed, it was you.
Yes.
And you didn't get very far with that. And no doubt it wasn't a matter of enormous significance, because it seems that it was really rather a peripheral aspect of the proceedings as a whole.
I agree with my lord completely, save for one key point, if I may. The only finding the local authority was seeking, and that was that there'd been violence by the first father to those two young people, had not been determined. So it was distinct from the other findings.
So those were the 5 findings that the district
That's right, couldn't make.
left
Yes.
undecided.
And I have to be careful with my language, because it wasn't that he didn't make the findings, he didn't determine them.
Yes.
And that's in the district judge's judgment, and it's repeated in the learned judge's judgment.
I don't want to draw you into, as it were, characterising your case in a way that might be unhelpful or unfair to anybody else, but I don't read from the judgment that you were making a very strong point about the findings made by the findings that were made by the district judge, and it was to reject them, the mother's case.
Absolutely.
That it wasn't that it was one of your leading points that she was hopelessly unreliable because the district judge had found it.
Yeah, absolutely. And my lord, on behalf of the local authority, I was seeking to establish threshold. And of course, relevant days takes us, those findings take us well back. So no, absolutely. That was not the focus. If I may then just point 5, the influence of the maternal grandmother. Well, it said that this was the central point that was put on behalf of the second father.
Well, I understood Mr. Tewin to be saying that it was the point that he was isolating for our consideration today, rather than that it had been the key point made by Mr. Alan Brand.
Well, I'm grateful for that, because I was going to remind the court that the learned judge had 160 pages of submissions and legal points submitted by all of us, but an awful lot to consider. So if it suggested that was my misunderstanding, if that had been suggested to be the main point, I respectfully submit that she'd certainly dealt with it in enough detail. But on that point, on the detail, my learned friend took you to 417 and 419. And of course, no doubt, my lords and my lady will have read 418 as well. And of course, at paragraph 418, that does give us the learned judge's evaluation on that particular point of the evidence. We read earlier in the judgment, in detail, what the judge thought of the grandmother. And at 417, but particularly 418, my submission, the learned judge sets out her reasoning why she did not accept that it would be, as well as the fact that that was not the case that was being put by the young people, but it would not seem most likely that the allegations were made on the basis of coaching from the grandmother, and includes in that, of course, the issues such as shame, honour, the family, and they were themes that we'd heard in the evidence as well. So, in my respectful submission, that passage of the judgment alone deals with the conclusions in relation to that particular case that was put. It's right that earlier on, the court had considered the evidence of the grandmother, and being as generous as possible, one could read into the judgment that she was what she was as a witness. But it is, excuse me, abundantly clear in my respectful submission that there's nothing missing from the conclusions that the court reached on that as a motive for the allegations the girls were making. Of course, I don't reverse the burden in saying that. And then, excuse me, the final point, I've touched on this earlier, and I think my lords corrected me in my misunderstanding. If the suggestion was made that the court, that this judgment is open to criticism for lack of detail about submissions that were made by all the parties, I've made the observation, starting at C14, there are 160 pages of submissions between all of us. We all take responsibility for. But it couldn't be right that it would be incumbent on a judge to repeat all of that. It must be right, and there's clear guidance on that the important points sufficient to allow anybody reading the judgment to understand why the court's come to the conclusion, and why, if they are the litigant, I don't mean this as an elegant news it sounds in a case such as this, but why they haven't got what they want, or why they've lost. And that's perfectly clear from reading this judgment as a whole. So, my lord, on behalf of the authority, I would invite this court to refuse both appeals.
Thank you very much, Mr. Paul. Yes.
Yes, I don't think, my lords and lady, I've got too much to add. I've concentrated on the res judicata point.
Yes.
And you've seen that in my skeleton, which starts at A210. And in fact, I go through it. But one point I'd like to make is the learned district judge was asked to make findings in two areas. One was the area of the relationship between the mother and the father. You heard of rape allegations and beating. The second was the allegations that when the two children were living with him abroad, they were physically chastised. That was the only allegation that the local authority sought against my client, the physical chastisement. And that didn't need to be reopened, because it's been hinted at C1019, the district judge said, I have considered whether I should make a formal finding that allegations 6, 7, 8 and 9, and they're the allegations against the physical chastisement, are not proved. I do not think this is the appropriate course given the inability to properly test the allegations. The Section 7 reporter didn't speak to the grandmother or the father, and he says he notes in passing that the father firmly denied them. So when in the skeleton argument of the mother, at A29, paragraph 48, they talk about the local authority relying on the historic proceedings by alleging that the first father had in the past been physically abusive towards the two elder girls. This ran counter to the district judge, to the judgment of the district judge. Thus, the local authority wished to reopen the findings. Well, there were no findings to reopen in relation to the...
So you say all this arose out of the first part of the district judge's decision, which related to the allegations made against your client but not accepted
By the mother.
By the mother, not to do with the treatment of the children, and that it was the mother who set this hair running without any proper process.
Because the only person who questioned in submissions whether it was appropriate to raise those allegations against my client 16 years previously was me in submissions, and the judge makes this point at A168 in her... It's paragraph 507. In closing submissions, it's raised on behalf of the father that the findings brought against him in respect of the physical abuse is disproportionate given their ages, and of course they're not party to the proceedings. And she goes on to say, on behalf of the local authority, this issue was not really probed. The girls weren't particularly challenged. And what she goes on in the next paragraph to say was, I query whether or not this position was informed by the fact that it was the local authority's own social workers who had in the past investigated some of these matters. So I was the only person who was questioning whether it was proportionate in relation to the physical chastisement. The mother was the only person who was concerned about the allegations that the judge did find. There was no application ever made, and you will be aware that under Re-B and Re-ZZ, that three-stage test has to be raised and has to be dealt with. It's often raised prior to the final hearing as a sort of preliminary point before a hearing ever gets started.
Yes, and this is nothing to do with the unexpected evidence that was given during the course of the hearing. This was an issue that was visible from a long distance beforehand.
And you will be aware that it wasn't really raised with the mother by her own counsel. It was raised in or attempted to be raised in cross-examination of my client and the grandmother. And I think it's fair to say it was me that stepped in and said, well, this has already been adjudicated upon, and you can't just suddenly... We must have been on day 10 by then, when these allegations were of the age of the marriage, these kind of issues were raised.
And by that time, the mother herself
had given evidence. And the point I make, and it's made in my skeleton, that you don't get to Re-B or Re-ZZ unless an application is made. And even if you got there, it says it can't just hope that you're going to get a different opinion by a different tribunal. There's got to be some further evidence that you can put before the judge as to why any findings could be reopened. Well, we didn't get there, and I think the parting shot, of course, is Miss Littlewood very, very boldly agreed in her written submissions at C150 that you couldn't go behind the judgment of the district judge. So then to criticise the learned judge for not doing this three-stage exercise seems a bit obtuse. I don't think I can say much more than that.
No, and I'm sure Mr. Toomey doesn't take it personally.
No, I don't think so.
Anything else? No, thank you, Miss Hughes.
Thank you.
Yes.
No is the answer, though their friend might. The way I like to read C-150 is that in the light of the judge's decision, she most certainly could not go behind the district judge's findings because she had not been permitted to in the course of that exchange. And their friend for the first father is quite right. It was she who objected. She raised the objection. When she raised the objection, the mother had already given her evidence, and in her witness statement, the mother repeats many of the matters about her past, her childhood, being forced into marriage, and the experiences she faced. So those are all before the court. They're before the court in her witness statement and in the expert evidence, and in particular, as I say, in the counselling report.
But I mean, I think, Mr. Toomey, one is bound to reach the conclusion that if this was going to be revisited, it ought to have been dealt with at the pre-trial stage long before the matter ever came in for final hearing.
Well, I think for our part, of course, that's right, and we say that REB puts the onus on those relying on the former findings, if they wish to rely on them in these proceedings, and that it was very clear on the face of the papers that the mother was going behind those former findings. It was only when the objection was taken on behalf of the first father that it became an issue. So we say the obligation was on the first father to raise them in advance, and this is a different situation to other cases of reopening. It's the issue estoppel point. And the consequences, we may just deal with 2 or 3 points by way of reply. Still on this point, the consequences for the mother, my Lord's, in exchange with the local authority, or from Mr. Poole, has questioned the local authority's position in respect of this allegation. Of course, the local authority, what it wasn't doing is it was not seeking to prove that the mother had coached the children. The local authority was seeking to prove quite the opposite, that the children back in 2015 were telling the truth. But the judge makes that finding. And so paragraph 511, A169, she makes the finding, the last 3 lines, the allegations made against their father to the CAFCAS officer, that they were untrue and they were coached to do this by their mother and the stepfather. And yet she makes that finding without any reference to the opinion of the CAFCAS officer at the time. And I've taken my Lord to it. So in our submission, this is a matter that went to the heart of her approach, the mother's credibility. Not only did it start out badly, because she was fixed with those findings, fixed with the view of her as a liar, but it ends with a finding that even the local authority wasn't seeking, and an extremely detrimental finding, namely that she had coached her children. The court was addressed in relation, on behalf of the local authority, to the mother's case at trial. I would submit that the mother's case is fairly described on her behalf at C152 by Miss Littlewood, where she sets out paragraph 26, the Islam report, where the mother had moved somewhat in her understanding, and conceded at paragraph 27 the mother rode back. But she makes the point that the mother's case was that she didn't know whether most of it was truth or lies, but what she did know is that she was clear that the second child was making up allegations that simply were not true. And so when my friend for the local authority takes the court to paragraph 299 and 300 in the judgment, just wonder whether, in fact, the last sentence of 299 is what the first sentence of 300 refers to. In other words, the mother said the child was making up these allegations. The mother was certainly of the view that the allegation described in that last sentence at 299 was fabricated. But her case in our submission was set out fairly on her behalf by Miss Littlewood at paragraph 27 of the written submissions. May I just see if there is any other?
Yes.
And my Lord, as Miss Littlewood asked me to remind the court, that is precisely why she sought clarification from the judge as to the evidence that she relied on in support of the second child's new allegations. And my Lord, my Lady now.
I'm sorry, I haven't engaged with that point. Could you just put it out, set it out again? Are we talking here about the email?
Yes.
Or, yes.
Yes.
Asking for a written note of the judgment, and particularly the analysis of the evidence on each allegation, so we can advise.
Yes.
So, reading that now, I understood what I didn't understand earlier on, which is Miss Littlewood wasn't asking for another document. She was asking for the, as it were, the main bits of the judgment.
Well, yes, certainly. Whether that was a different or the same document, she was asking for analysis of the evidence in respect of each allegation. Is it a separate document?
We haven't.
I think we were leaving that to the learned judge, but
Yes.
we wanted the analysis. The final point I think I should make is a response to their friend Mr. Tuan's appeal, and it's simply this, that we respectfully disagree with the submission that this court would be unable simply to draw a line through an allegation that had been found by the learned judge, but which this court considered to be unsafe.
So you disagree with the all or nothing?
Validity.
Yes. I understood that.
Unless that consists of laws further, my lady.
No. No. Thank you very much, Mr. Tuan. Mr. Tuan, anything further?
Not unless I can assist, my Lord.
All right. Well, we'll rise for some 5 or 10 minutes. Please feel free to stretch your legs until, say, 25 to 4, and we'll come back as soon as we can after that.
Oh, fine, yeah. So let's go out to court then. Do you hear that, folks?
I don't know if you'd rather just go outside.
John. That's staying on, so if you want to go out, if you want to talk. The manager guy is staying on.
Well, probably if it was like a half an hour.
Yeah. Is this in most of them now? Or are you finding the live stream? You're doing the live stream in most of them now? Yeah. It's good to get used to that.
There's a couple of juries in Nairobi. They're doing a criminal trial here.
Some trials?
Yes.
In the road.
So the Prime Minister
I
think he's saying we will have to work.
called a nightingale.
Oh.
And he said,
What does he say? He said different things.
Yeah.
Legislative crime, I can't remember. And the
Is everybody back here?
Yeah. Now. Yes. Yep.
Everybody's ready?
Yep. Yes,
Because we've got Clark in the building. So the human interest.
he's on leave at the moment.
Oh, is he?
Yeah.
Oh, nice. You do court proceedings?
Yeah.
Have you been in front of him?
Not in the court.
No.
No. That means we won't be working.
Have you been away?
I went to Devon.
Oh, no. I went to Dawson. 5 days.
I'm going to Scotland on Thursday.
Oh, lovely.
That's why I didn't know that case was on. I may try and do it because it's hard to give it.
Yeah, be right. She's moved now.
She's at Central.
No, I don't know. I mean, thank you, because it's quite
she did.
Yeah, all the other two things.
You didn't.
You sure? Yes.
Being watched, Mary, being watched.
I mean, I work so, I just work so. We got paid 2 days.
I know, I do as well. My sister went to New York. Did they pay you? Oh,
I'm
just
generally
new friends.
Sorry. I know, we get paid
You know.
Yeah.
No, I don't mean that.
I've really missed it.
But it was,
It
just took.
Yeah.
did all right.
I was in your neck of the woods. Yeah, I went to. What's that London? Port Rush. And then on to Portsmouth.
Yeah.
It is. Isn't it beautiful? I think people don't know about it. They know the weather's great. It's just a beautiful, most beautiful spot, and it's much worse.
I do struggle. I think part of the series was just that
Because I normally go away.
you go off.
Yes. Yeah. No, I know.
Look for Scotland. It's raining every day. But I've never been to the islands.
No, I think it's worth it.
I've never been before.
That sounds lovely.
I went to there.
Oh, that was really easy to good.
I've only done extraordinary not.
I love the chance because my go-to.
I booked a hotel.
Something spiritual about not spiritual.
Yeah,
You are heritage. Both my
criminal law. If you go there for prison, doesn't know you can do this. Is it? Yeah.
Well, I think there might be 3 prisons on there.
Right.
Yeah. Can you imagine what
I
children's
would
like?
say Mr. Tooth, I would say Mark's Who's the judge that's now? He's the circuit judge sitting in Portsmouth.
Oh yes, him.
Him.
In the CSC.
Yeah.
When was the one that was?
You know, like Marsh.
Yeah. Yeah.
Well, that just sounds like common sense.
She was executive.
All right.
Yes. May we thank you all very much for the efficient way in which this appeal has been prepared and presented both in writing and in orally before us today, that has enabled us to hear the arguments within the course of the court day. We are in a position to inform you of the outcome of the appeals. That is that the appeals will each be dismissed. We will give our reasons in writing because of the state of the underlying proceedings. We are sure that it would be helpful to the parties and to the court if you had those reasons before next week when the matter is back in court. And we will therefore do our best to let you have our reasons during the course of this week, so that the parties in the court should at least know the reasons for the outcomes in draft, even if the decision has not been formally handed down. Depending upon when we can let you have that document, we may need to abbreviate the lengths of time that we would normally give you to proofread it, make corrections and suggestions. But I know that the parties are aware of the process, which will mean that we will give you a time by which to suggest those amendments and at the same time to provide a draft order, which I don't think is likely to be very long in the circumstances of this particular case. Unless there is anything that any of the parties would wish to mention before we rise, I repeat our thanks and bring the hearing to a conclusion.
All right.
Right, if you take that. Are we all working?